Welcome to the LSAT Reading Comprehension lesson. And today I'm going to show you the proper way with proper techniques, strategies, direction to how to get a high score on the LSAT. So how we will skim, how we will read the passage from head to foot, how we will mark important points, essential ideas, names, definitions, and so forth. Then we will circle the heart of each question, I mean the best titles, author's purpose, which must be true, and so forth. And then we will use the elimination strategy. Then we will determine quickly that a particular passage is difficult to understand, and many so. So here we do have some sample passages, and now is sample one. Actually, I would like to demonstrate you my market passage with the highlighted points, keywords, expressions, and sometimes the whole or part of a sentence. Here, how it should look like this with your highlighted points. So let me read for you first to take the advantage of our answering with the whole and deeply explanation. So for most of recorded history, the law treated children and adults alike, and so they were subjected to the same procedures and punishment. It was not until recently that a separate system was established to handle juvenile defendants. Actually, I've highlighted this half of sentence just for your information for our questions. We'll go forward and I will give you some explanations and deeply details. So early reformers believed that in handling juvenile offenders, society should not be concerned with whether the child was guilty or innocent, but rather with rehabilitating him. The underlying philosophy of the juvenile justice system was this: because the child brought within the system is essentially good, he should be treated not as a criminal. So I've highlighted this half of sentence as well, but as a neglected child who needs care and guidance. Therefore, a criminal proceeding was considered inappropriate. Let's go forward. This basic philosophy is present in each state's juvenile justice system. Also, the systems vary from state to state. They all operate under the premise that the emphasis should be on the offender rather than the offense, on rehabilitation rather than punishment. Okay, here is emphasis should be rehabilitation rather than punishment. That's great keywords. In juvenile proceedings, formality and strict rules of procedure have given way to informality and flexibility. In the process, constitutional protections generally according an adult offender will not apply to proceedings involving a minor. I've underlined this half of almost the whole sentence for your information. As a result, the juvenile justice system has been criticized because the treatment ordered for the child was often harsher and more arbitrary than that for an adult. For example, not only was the juvenile denied the appellate recourse available to an adult offender, but also he or she often never received the promised protection and rehabilitation. In 1967, so remember, you need to take this key point this year. The Supreme Court began enumerating what rights should be applied to juvenile proceedings. Among those procedural protections, the court recognized the adequate notice of charges, representation by counsel or by appointed counsel, privilege against self incrimination, and opportunity to confront and cross examine witnesses. In 1970, once again, this year will play a crucial role on your questions. Please pay particular attention on that. So in 1970, proof beyond a reasonable doubt was required. When the youth had been charged with an act which would be a crime if committed by an adult, while incorporating safeguards into juvenile proceedings, the court did not ignore the basic approach of the juvenile justice system. It was careful not to unduly inhibit the informality, flexibility, or speed of the proceedings. In order to do so, the need for constitutional safeguards was often balanced against the need for fair and speedy treatment of the minor. In a later case, in 1974, a 17-year-old was charged with conduct which, if committed by an adult, would have constituted robbery. At the adjudicatory hearing, based on the testimony of two prosecution witnesses and of the defendant, the juvenile court found the allegations to be true. And at a subsequent hearing, adjudged him to be unfit for treatment as a juvenile and ordered that he be tried as an adult. This the court found violated the double jeopardy clause of the Fifth Amendment. Here, dear students, you need to pay particular attention of the name of this amendment or clause. It will again play a crucial role on your question. In that evidence was introduced at the adjudicatory hearing to determine if the juvenile committed the act charged before a determination was made whether to transfer him to the criminal court to be tried as an adult. Allowing a transfer thus satisfied the need for flexibility, as in some instances the youngster will most likely not benefit from the specialized guidance and treatment provided in the juvenile justice system. But such a determination must be made before evidence is heard on the merits. The court, while realizing that mandating a transfer decision before an adjudicatory hearing does impose an additional burden on the juvenile justice system, concluded that rather than inhibiting the flexibility and informality of juvenile proceedings, likelihood of better treatment of the youth will be increased. These Supreme Court cases concerning juveniles have raised issues of due process pertaining to the adjudication stage of the proceedings. However, it's still unclear what rights attach at the initial detention stage. Actually, last paragraph is very essential as the first one. In this area where constitutional safeguards have yet to be defined, state law still controls. We will go to our questions and you will see why I have underlined and highlighted, marked some keywords. So let's get started from the first question. The passage is concerned primarily with A option, the juvenile justice system in the United States. B option, the rehabilitation rather than the punishment of juveniles. C option, the needs of juvenile defendants in criminal proceedings. D option, the constitutional safeguards of juvenile defendants. And E option, constitutional protections and juvenile proceedings. So here it is. It's very evident that our option is E, constitutional protections and juvenile proceedings. Actually, also, all five of the choices are plausible. The focus of the passage is on juvenile justice proceedings and some Supreme Court decisions, which I have already highlighted for you, decisions guaranteeing constitutional protections to the defendants. Next, second question. In the United States, the juvenile justice system is based upon the unproven assumption that A option, children are good rather than evil. B option, hearings should be informal and speedy. C option, misbehavior should be punished. D option, the laws of evidence cannot be applied to minors. E option, children, like adults, should not be subject to double jeopardy. So here, our answer is A option. Children are good rather than evil. The first paragraph of the passage asserts that the underlying philosophy of the juvenile system is that child brought within the system is essentially good. The system supports informal and speedy hearings. This is choice B. Hearings should be informal and speedy, but cannot be said to be based upon them as an assumption. Let me show you the first paragraph. Here, the underlying philosophy of the juvenile justice system was this: because the child brought within the system is essentially good, he should be treated not as a criminal, but as a neglected child who needs care and guidance. Therefore, a criminal proceeding was considered inappropriate. Okay, that's correct. Let's go to the third one. It can be argued that at one time a juvenile offender was at a greater disadvantage than an adult for all of the following reasons, except A option, he or she may be denied protections as an adult would automatically receive. B option, the chief concern of the juvenile court is the offender rather than the offender. C option, the offender may not be protected against self-incrimination. D option, he or she may not have been represented by counsel. And D option, a juvenile may never have had the opportunity to appeal a decision. So our answer is B. The chief concern of the juvenile court is the offender rather than the offender. This is the exception. Also, I can say that the statement of choice B is true in paragraph second. It would not necessarily support the argument. All of the other four choices are genuine disadvantages that might once have existed. So let's go to our second paragraph. Here, this basic philosophy is present in each state's juvenile justice system. Although the systems vary from state to state, they all operate under the premise that the emphasis should be on the offender rather than the offense, on rehabilitation rather than punishment. Let's go further. Fourth question. We can infer from the passage that before 1970, that's why I told you that you need to highlight or circle or mark wherever actually years. In a juvenile hearing, a charge that would be criminal in an adult court. A option would be transferred to trial in an adult criminal court. B option could not be transferred to trial in an adult criminal court. C option would not have required proof beyond a reasonable doubt. D option would not be brought to trial speedily. E option would be tried without the informality used in a juvenile court. So our answer is C. Would not have required proof beyond a reasonable doubt. Because the passage specifically points out the retirement of proof beyond a reasonable doubt in 1970. And the paragraph is listing the gradual increase in juvenile rights. We can assume that this protection may not have existed before 1970. So we started in 1970. Proof beyond a reasonable doubt was required when the youth had been charged with an act which would be a crime if committed by an adult. Fifth question. In lines 29 till 36, the author cites the case of 1974 in order to, we have already circled this year. First option. A. Demonstrate the need for flexibility in the juvenile courts. B option. Cite an example of juvenile rights properly protected. C option. Support the case for increased protection of juvenile rights in state courts. D option. Cite an example of the failure to incorporate safeguards in the judicial system. And E option. Demonstrate the need for fair and speedy trials of minors. So here is our correct answer is B. Cite an example of juvenile rights properly protected. Actually, the case cited describes the High Court's reversal of the juvenile court's decision and is an example of juveniles being given the same protection an adult could expect. So here, in a later case in 1974, a 17-year-old was charged with conduct which, if committed by an adult, would have constituted robbery. At the adjudicatory hearing, based on the testimony of two prosecution witnesses and of the defendant, the juvenile court found the allegations to be true, and a subsequent hearing judged him to be unfit for treatment as a juvenile and ordered that he be tried as an adult. Sixth question. We can infer that compared to their rights at adjudication hearings, the rights of juveniles at the time of their arrest are A option, very nearly the same. B option, different from state to state. C option, clearly defined, D option seldom threatened, any option similar to those of adults. Here it is, our answer is B, different from state to state. According to the final paragraph, the constitutional safeguards at this time are yet to be defined and are determined by state laws. So, this final paragraph hints you to the proper and correct option. These Supreme Court cases concerning juveniles have raised issues of due process pertaining to the adjudication stage of the proceeding. However, it is still unclear what rights attach at the initial detention stage. In this area, where constitutional safeguards have yet to be defined, state law still controls. And the final question is, the author of the passage probably regards the present juvenile legal procedures are. First option A, unfair to the juveniles. B option, unfair to adults. C option, improved but with more to be done. D option, fair to both juveniles and adults. And E option is ideal. So here, our correct option is C, improved but with more to be done. How is that? Let me show you the way, the strategy, and the right techniques. Given the question, here the author of the passage probably regards the present juvenile legal procedures are, the adults are irrelevant. Also, much of the passage is approving. It is transparent that the author believes more can be done to protect juvenile rights. So, our correct option is C, improved but with more to be done. So, here we can actually see the obvious mentions from the first paragraph. For most of recorded history, the law treated children and adults alike, and so they were subjected to the same procedures and punishments. It was not until recently that a separate system was established to handle juvenile defendants. So then we can see from the second paragraph, although the system vary from state to state, they all operate under the premise that the emphasis should be on the offender rather than the offense, on rehabilitation rather than punishment. Next, in 1967, the Supreme Court began enumerating what rights should be applied to juvenile proceedings. While incorporating safeguards into juvenile proceedings, the court did not ignore the basic approach of the juvenile justice system. So, without my help and assistance, you can read this material, handout material from head to foot, download these very easily, and you can read these on your free time. Then you will see the obvious answers to our questions with my speech, and I'm going to show you the way of my speech. Also this on my handout materials, you can see this speech there, and you can follow all the questions, answers, the strategy, the techniques there very easily. So go beyond and go forward with these techniques and you will get a higher band score. On the next lesson, we will go with the sample second. Here it is. You will have some structure of this second sample and it will be very easily to find an answers for that time because you have already practiced and actually you need to practice all the time to get a higher score. Then you will have questions there. You will have 5 questions to be answered properly and I'm sure you will be do that very easily with my techniques and strategies and I hope this lesson was very helpful for you and you will get your highest score as soon as possible on your required time and on the next level you will see how you can hint the subject very easily with specific key terms, years, and some circling information which will be very helpful for you. And as I told you previously, you need to mark just a few key items per paragraph. Being careful with that. Marking key points help you to stay focusing on the task at hand. And you need, as I told you previously, circle the heart of each question. So, as title, author's purpose, and many others to help you avoid careless mistakes in misreading what is actually being asked. And actually, you need to use the elimination strategy of crossing out obviously incorrect choices as we have already done before. Thus, avoiding having to reconsider them to help you save valuable time. And determine quickly that a particular passage is difficult to understand. If it is so, you may wish to leave it for last, but don't leave your blank empty. Even if you leave a passage and its question to do last, fill in guesses for the questions, just in case you don't have to time to return to them. What about skimming, guys? Actually, some candidates have found that skimming the questions but never the answer choices. Before reading the passage helps them to know what to look for when reading the passage. But it's not the right strategy. Others maintain that the questions are of such a general nature that skimming questions beforehand isn't particularly helpful and, in fact, wastes valuable time. In this regard, you should use these practice materials, my materials, to discover which approach is effective for you, which is working for you. So I suggest you will practice all the time and you need to read the passage from head to foot. You don't need to pay attention to others who said that you don't need to read the passage whole. Actually, it's very easily to read and very practically because you know the answers beforehand. You need to circle, determine, and highlight and even underline your keywords, some messages from your passage to your questions, and in that case, you will get your highest score. So, I wish you a success and I hope this lesson was very helpful for you on your LSAT reading comprehension, strategy, and section.